Hey there, Legal Tea listeners. This is your host, Jenny Roselle. Today's episode of Legal Tea is a cautionary tale where we talk about real-life cases with real-life facts and clients. They're things me or my office have worked on. And for today's episode, we're going to be talking about an important topic and one that I think some professionals would get uncomfortable to talk about, but I'm a big fan of uncomfortable conversations, not because I like them, but because so often that's where you can identify places and ways to grow, to do better, and to be better. What's the topic, you ask? Well, it's taking legal advice from a non-attorney, which sounds like, well, duh, Jenny, that's a bad idea, but yet it still happens all the time. And I'm not even talking about taking legal advice from, say, family or friends. Heck, people will always do that. And even though I say, don't take legal advice from non-attorneys, people will still turn to family and friends. But instead of talking to family and friends for this specific episode and topic, I am talking about clients taking legal advice from another professional, like, say, a financial advisor or an accountant. And just hear me out. I'm going to share a couple of stories today. It is cautionary tales after all, that have very recently happened and where this has occurred because I think it beautifully shows what I mean. And by the way, before I dive in, please don't think I'm harping on other professionals. That's truly not my intention here. And trust me, I don't think that lawyers are faultless. I'm simply hoping that having this conversation will honestly promote better communication among all professionals, including lawyers to lawyers, and better communication between professionals and their clients. Alrighty, let's dive in. First story, I had a client, and let's name him Bob, come in to see me, and after we thoroughly discussed his estate planning goals, his family, and his assets, I presented a few options that I felt were appropriate to bring up. In an effort not to bore you with details that aren't pertinent to this conversation, he ultimately elected to do a revocable living trust. And of the options I presented, if I were him, that's exactly the option I would have picked. So fast forward some time, like maybe a week or so, and I hear from the client that he talked to his financial advisor, and the advisor said, quote, he didn't need a trust. Unfortunately, I've dealt with this pushback before so much that at this point, I am so used to it. And like I said, I'm not harping on this financial advisor. And actually, to come to their defense a little bit, there are attorneys out there that will present options to a client that are honestly inappropriate. So I'm certain the advisor was just trying to look out for his client. And here Bob, and I'm talking about this fake client. Well, I guess it was a real client, but we're using a fake name, Bob. Anyways, I suppose what I would have much preferred is Bob's financial advisor picking up the phone and saying, hey, Jenny, can you tell me a little bit about what the general plan is with Bob? Rather than blankly saying to Bob, you don't need a trust. So instead, in Bob's case, I picked up the phone and called the advisor, which I would have done anyway because my world is so closely intertwined with theirs. Like me chatting with the client's financial advisor is very, very common. So we start chatting and it's cordial, it's fine, and then I jump into the trust conversation. I explain that Bob is trying to accomplish two very specific things, that to make them happen through a will would require the probate process. So in effort to bypass probate, putting these very, specific things in a trust not only allows Bob to accomplish those two very specific things and keep out of the whole, drawn out, time-wise, costly probate process. And you want to know what those two very specific things were? First, Bob's wife was not his kids' mother, and the house he and her lived in was in his name only. Now, if he were to pass before her, Bob wanted to give her the authority to continue living in the house, so the kids couldn't kick her out. But also at her passing, he wanted the house sale proceeds to go to his kids, not her. And the second very specific thing he wanted to accomplish was that one of his kids was special needs. So receiving an inheritance would negatively impact the disability benefits he was on. Therefore, Bob wanted to have that child receive his share in what's called a special needs trust, so it would not hurt the child's benefits. Can I accomplish both of these things through a will? Sure can. But to make those terms come to life in the will is going to require probate, which is going to cost Bob way more than the trust would have ever cost. And once I explained all of this to the financial advisor, he was like, well, sounds like you sure know what you're doing. And so bad, I wanted to be like, yeah, I know what I'm doing. And I promise I'm not trying to pull a fast one on Bob. Though because the financial advisor said this to Bob, Bob got confused and started second guessing things. And I had to sort of reconvince him that the trust was the best option for him. And it was the best option. I think what I find most troubling about this story is, what if Bob had totally bailed and said, hey, I'm taking my financial advisor's legal advice that I don't need a trust. And then if he would have done that, three things would have happened. First, since his wife was not a beneficiary in his estate plan, she could have sued his estate to recover what is called a statutory spousal allowance. So what that means is you basically cannot disinherit your spouse without a prenup. So she could have kicked up a fuss. Second, the wife could have ended up having to move out of the house she lived in, which is not what Bob wanted. And third, the special needs son would have inherited and lost his Medicaid benefits. All of that could have happened if Bob took the very general legal advice of his financial advisor. Though thankfully we got things straightened out, his advisor was on board, and now Bob has a beautifully crafted estate plan to prevent all those bad things from happening. But what if he didn't? What if he would have bailed? Okay, second story time. This story consists of an older lady that we're going to name Nancy. So Nancy and Nancy's daughter come into my office, and Nancy is interested in learning about asset protection planning, specifically against long-term care costs and Medicaid. She had modest assets. She had, I think, a couple bank accounts, a house, an investment account, a small retirement account, and a life insurance policy. And long story short, she told me, Jenny, I worked my tail off and I want everything to go to my kids, not the nursing home. And you see, when people bring up the topic of asset protection planning, you're definitely looking at a trust, and likely an irrevocable trust. And now when I say irrevocable trust, people get scared of that word. And it's not nearly as scary as it sounds. In fact, the individual remains the trustee. So here, Nancy would have remained the trustee or the manager of the trust. There's still what's called a power of appointment, which is just a fancy name for, hey, she can still change things. And they even retain a significant amount of control. So I talked to Nancy about this type of trust, and she was totally on board. Fast forward some time again, I see her a couple weeks later, and her and the daughter are at their next meeting, sitting in the conference room, and they start off by saying, "Jenny, boy, do we have lots of questions." And I said, "Okay, no problem. I'm used to that." Well, long story short, their accountant totally scared them out of this trust. He said, first, Nancy couldn't be the trustee, which is wrong. Second, that it would have to have its own tax ID number, and that would result in a higher tax bracket, which again is wrong. And third, Nancy can never change anything. She can never amend it, which yet again is wrong. So, like my last story, I hear these same things from different clients with different advisors all the time. Yet again, this accountant is giving them inaccurate legal advice, right? And in doing so, not only confusing our mutual client, but they're possibly harming the goal Nancy is trying to accomplish. And you see, back in the day, irrevocable trusts were much different. They were like all the things he mentioned. But that was like 20, 30 years ago. And while I don't expect him to keep up with the laws, I also don't expect to spew out inaccurate and inappropriate legal advice. And sorry to be so snarky, but to be honest, I don't question how he prepares the tax return. So why are you questioning my intention? So yet again, I had to play cleanup, and guess what? This story ends different than my last story. Nancy totally backed out of doing the trust, and she backed out of doing the trust that 100% would have satisfied the goal she came into my office to accomplish. So now she's very, very likely too old to obtain long-term care insurance, and even if she could, it'd probably be super, super expensive. So if something happens to her and she needs nursing home care or home health care, she's paying privately. She's paying out of pocket, which is what she told me she didn't want to have happen. Will I be impacted by that? Absolutely not. Will Nancy? Yes. Will Nancy's daughter? Well, her inheritance will be less, which is, again, something Nancy was trying to accomplish of not happening. Will Nancy's financial advisor be impacted? Well, his assets under management will continue to decrease, paying privately for this venture. So I'll let them decide if that impacts them. Will the accountant be impacted? Probably not. I certainly don't mean, I promise, I don't mean for this topic to come across any way of me harping on my fellow professionals. And like I said earlier, I truly come to their defense, and especially after sharing these two stories, because my profession is not squeaky clean either. I mean, how many lawyer jokes are out there, right? And most of the time, those other professionals are truly coming from a place of trying to protect their client. And at the end of the day, it is well-intentioned. But their good intentions have very real and sometimes bad impacts on their clients. One of my favorite sayings in the world is, "You don't know what you don't know." And in that second story, that accountant didn't know irrevocable trusts aren't that restrictive anymore, and that they've drastically evolved. Or even in that first story, that financial advisor didn't know what Bob had shared with me on what he was trying to accomplish. They didn't know what they didn't know, right? But you know what would have just prevented all of the confusion? Just picking up the phone and calling. And thankfully, as I have a decade of experience under my belt now, more and more financial advisors know me at this point and know I'm not the kind that's over here pulling fast ones on their clients. That's just not me. I enjoy putting my head on my pillow at night and knowing I did a good, honest job. But because this type of thing happens so much, I think there's things that I've learned to do. And if I am working with the client and I say don't know their financial advisor or their accountant, I try to remember to just go ahead and get ahead of the conversation. So in those situations, I usually reach out and say, hey, I'm Jenny. I met with so-and-so client and this is what we talked about. And if you have any questions, just let me know. And simply taking that initiative, not only does it automatically build rapport and trust with the professional, but it also doesn't put the client in the middle. And it sounds very silly, but such a small little shift has just paid a lot of dividends and less confusion and things like that. So, maybe all of us professionals, including my own legal profession, should do better, and specifically do better at communication with each other for our clients. Alrighty, let's wrap up this episode. Next week, we are back to the current events, current trends episode topic, where we talk about something I've seen or run across, maybe on the news or social media, that I think would be interesting to talk about on here. During next week's episode, we're going to be talking about Jeffrey Epstein's estate and some scrutiny his estate's executors are facing. So yeah, tune in for that next Tuesday, Legal Tea listeners. Until then, be well and talk soon.